How to avoid the first-headed monster, disability probate. Oh my! Hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is, what is a power of attorney? Folks, very good question and very critically important question. What is a power of attorney? Folks, pull up your chair, get your pen out, and get your notebook out, because today I'm going to teach you what a power of attorney is all about. You may know me as the author of How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. Strongly recommend pick up a copy today, now, on Amazon, because I will teach you how to slay the metaphorical four-headed beast. And today, one of the first-headed beasts is probate court. First-headed beast, probate court. And is actually, probate court is a two-headed beast, I often say, at our educational programs, because you got disability probate and then you have death probate. Today we're talking about disability probate. And I often say, sadly, unlike fine wine, we do not get healthier with age, because most of us from an actuarial standpoint will become incapacitated and decline in health as we journey through the path of life. And disability planning is one of the most overlooked areas in estate planning. When a person becomes completely incapacitated, they cannot manage their own affairs, they can no longer manage their own finances, they're more than vulnerable, and they're completely incapacitated. Maybe they have dementia, maybe they have Alzheimer's, and they're subject to being neglected or taken advantage of. And so it's really important for loved ones to protect them, to legally step into their shoes and manage their financial affairs in their best interest. But you cannot do that automatically. Even spouses, folks, you cannot do that automatically. If your loved one becomes disabled completely, they need to sign what I call the Big Six disability planning. And the number one of the Big Six is what we're talking about today, power of attorney. So folks, power of attorney comes in different sizes and different types, okay? A general power of attorney, you might be appointing a person to handle some financial affairs for you if you're not able to be available or if something happened to you. But in the context of elder law, we're talking more about a durable power of attorney. DPOA is the acronym. Durable power of attorney, folks, is the first sword to slay that metaphorical first-headed beast, probate court. So durable power of attorney, folks, is essential to slay that first-headed beast, probate court. And you want to make sure that your estate elder law attorney with experience drafts that durable power of attorney with what I call enhanced elder law powers to give your agent or your attorney-in-fact, which is a legal fiduciary, which means helper. Legally, they can step into your shoes, manage all your financial affairs in your best interest, while avoiding the stresses and messes of probate court, as well as what I call in my book, the economic and emotional headaches of probate court. Folks, because I had a case years ago, no names of course, dear client of mine, married to his bride for about 50 years at the time. Sadly, his wife was diagnosed with severe dementia and she was in a local hospital. The gentleman, the husband of 50 years, was simply trying to move her from the hospital to a nursing home facility. He found out quickly that he had zero legal authority to do that. So off to the probate court we petitioned for guardianship, so he would have legal rights to manage her medical affairs. Second piece of this, he had to sell a second property to private pay the $15,000 per month nursing home. Guess what? His beloved wife's name was on the deed. Could my client, the husband of 50 years, pick up a pen and sign his incapacitated wife's name on that deed legally and sell the property to private pay the nursing home? The answer was absolutely not. So we had to petition the probate court a second time for a legal office called Conservatorship. 6 months later, 3 attorneys, the court appointed 2 court-appointed attorneys, a guardian ad litem and a Rogers attorney, court rules, probate court rules, oversight rules, and our client is paying not 1, not 2, 3 attorneys by the hour with the meter running. So unnecessary. So at the end of the journey, my dear client, feeling helpless and hopeless, exacerbated, not being able to help his wife of nearly 50 years, turns to me and says, "Patrick, you mean to tell me if so-and-so," referring to his dear bride, had just signed a durable power of attorney and a healthcare proxy when she was alive and well, we would not be here today? And the answer was a resounding yes, yes. So folks, durable power of attorney, so important, and you have to make sure it's durable, meaning that it's everlasting, that it survives your disability, it survives your incapacity. So, so important, folks. Durable power of attorney. Folks, first line of defense, number one in the Big Six disability planning, go out there, meet with your elder law attorney today and get that done, because the cost and the risk is too great without it. Folks, if you found this educational video helpful, please scroll down, post a comment, post a question, because a member of our Elder Law Care team will get back to you as soon as possible. Subscribe, click on the subscribe button, folks, because we will keep you updated on other very important elder law matters. Folks, great seeing you today here at elderlawcare.com.